The moment the clerk hit enter on that court order, something irreversible happened. Not politically, not symbolically, mechanically. The kind of thing that doesn't care about slogans, rallies, or truth social posts. A legal process began moving forward that does not pause for power. And for the first time in a decade, Donald Trump was no longer protected by delay, noise, or spectacle. The insulation failed. The system reached him where he is weakest, not in his rhetoric, not in his base, but in the balance sheet. For years, Trump has operated in a parallel reality where gravity seemed optional. Impeachments didn't slow him down. Indictments turned into fundraising emails. Civil judgments were treated like suggestions. Everything was postponed, appealed, bonded, delayed. Consequences were theoretical, always tomorrow, always someone else's problem. But early this morning, that reality ended. Because New York State didn't issue a warning, it didn't threaten enforcement, it executed judgment, immediately. And when a civil judgment is executed, it stops being politics and becomes logistics. This wasn't a press conference moment. This wasn't theater. This was the quiet, administrative sound of a legal machine switching from standby to active mode. A judge signed an order lifting the stay on enforcement of a civil fraud judgment. That single act removed the last barrier between Trump's private empire and state seizure. The bond that had been holding the line collapsed, the shield dropped, and suddenly, the Trump organization was no longer arguing in court. It was being inventoried. To understand why this is unprecedented, you have to strip away the drama and look at the mechanism. Trump was hit with a massive civil fraud judgment in New York for years of systematic financial misrepresentation. He appealed, which is his right. But under New York law, an appeal does not automatically stop enforcement. To prevent immediate seizure, the defendant must post a bond equal to the judgment. That bond is a promise to pay if the appeal fails. It's the court's insurance policy. Trump didn't post cash. He relied on a bonding company that relied on reinsurance. And that reinsurance was exposed to a global financial shock that hit overnight. The failure didn't begin in Manhattan, it began in Tokyo. The Japanese bond market cracked. Liquidity vanished. Carry trades unwound. What looks like a foreign financial story on paper became a domestic legal emergency in practice. The reinsurance backing Trump's appeal bond suddenly found itself overexposed, undercapitalized, and unable to certify risk. When that happens, regulators intervene or risk committees pull the plug. The bond was withdrawn, and when the bond disappears, the stay disappears with it. Trump had a narrow window to replace it. He didn't. Not because he didn't want to, because the credit market froze at the exact moment he needed it. Banks don't extend half-billion-dollar lifelines during global instability. Hedge funds don't touch assets under active seizure. Foreign money gets cautious when courts start moving. The phone calls didn't get answered. The checks didn't clear. And the court, seeing both the liquidity crunch and the defendant's history, made a calculation. Delay would only reduce recoverable value, so it acted. At that moment, Trump stopped being a litigant and became a judgment debtor. That distinction matters, because judgment debtors don't negotiate narratives. They get processed. Sheriffs don't care about politics. Receivers don't care about elections. They care about assets, cash flow, and compliance. And when the order went live, New York State gained the authority to identify, freeze, seize, and redirect revenue from Trump-controlled entities. This is where the story moves from scandal to collision, because Trump is not just a businessman, he is the sitting president. And some of the assets subject to seizure are intertwined with his physical security, his residence, and his identity. Trump Tower is not just a brand, it is a protected site. The Secret Service controls its perimeter. Federal authority occupies state territory. And now a state officer holds a court mandate to enforce civil law inside that space. That is how constitutional crises actually start. Not with declarations, with overlapping jurisdictions executing valid orders that cannot coexist without conflict. A New York sheriff has a legal obligation to enforce a court order. A Secret Service agent has a legal obligation to protect the president. Neither is acting unlawfully, but if both act simultaneously, the system strains. This is why the state moved surgically. The goal is not spectacle, it's leverage. Commercial properties first. Cash flow before residences. Bank accounts before penthouses. Under New York civil procedure, the court can appoint a receiver to take operational control of revenue-producing assets. A receiver is not an observer. They are a replacement. They collect rent, They manage payroll. They redirect income streams away from the owner and toward satisfaction of the judgment. Imagine that in practical terms. Tenants in a Trump-branded building receive a letter instructing them to stop paying Trump and start paying the state-appointed receiver. The Trump organization loses control without losing title. On paper, Trump still owns the asset. In reality, he has no access to its income. He becomes a landlord in name only. The building works for the state now. That alone would be devastating under normal circumstances. But this is not a normal market. Commercial real estate is already weakened. Interest rates have surged. Remote work hollowed out office demand. And now forced liquidation looms. Forced sales don't fetch market value. They fetch survival value. Buyers smell blood. Offers come in low. Equity evaporates. And when the asset sells below outstanding debt, the loss doesn't just belong to the owner. It cascades. Most commercial properties are leveraged. They carry loans. Those loans include covenants. One of those covenants is almost always triggered by major judgments or asset seizure. Even if the borrower is current on monthly payments, the mere existence of a seizure order can constitute default. That allows lenders to accelerate the loan. Pay everything now. Trump cannot. So the lenders move too. Foreclosure piles onto seizure. Multiple creditors converge. The asset becomes a carcass. This is why timing matters. The court didn't just act. It acted when Trump was maximally exposed. Campaign expenses, legal fees, frozen credit markets, global instability. There was no margin for error. And when the margin call came, he failed it. That failure is not political. It's mechanical. And mechanics don't care who you are. The White House understands the danger, not just to Trump, but to the office. A president fighting off asset seizure is distracted. A president threatening to intervene in state enforcement risks obstruction. A president who uses federal power to protect personal wealth invites constitutional retaliation. The line between governance and self-preservation blurs. That is when systems start to panic. There are reports of emergency legal strategies being explored, federal injunctions, claims of immunity, arguments that enforcement interferes with executive function. These are not frivolous ideas. They are desperate ones. The Supreme Court has already ruled that presidents are not immune from civil litigation, but liquidation during a term raises unanswered questions. Not because the law is unclear, but because it has never been tested at this scale. This is the danger of novelty. There is no playbook for a sitting president whose private empire is collapsing under lawful judgment. Every move sets precedent. Every denial sends a message. If the courts intervene to protect Trump's assets, they risk appearing captured. If they don't, they allow humiliation of the office. Either path carries legitimacy costs. The Supreme Court will likely be asked to act. Emergency stays, circuit appeals, narrow questions framed as national security concerns. The justices will be under extraordinary pressure, and they know the context. They know the polling. They know the market reaction. They know Trump's political volatility. They also know that shielding him may damage the institution more than letting the law run. This is the paradox Trump created. By refusing to disentangle his business from his presidency, he fused his personal survival to the state. Every attack on his wealth becomes, in his framing, an attack on the nation. But the law does not recognize that equivalence. The Constitution was designed to prevent it. This is why the Emoluments Clause exists, why blind trusts exist, why previous presidents divested. Trump rejected those norms. He treated them as optional. And now the bill is due. The system is forcing a separation he refused to make voluntarily. The psychological dimension matters. Trump does not experience wealth as security. He experiences it as identity. His buildings are not investments. They are extensions of self. Losing control is not financial pain. It is existential threat. That explains the volatility, the rage, the impulsive threats, the fixation. A cornered leader is dangerous. History shows this repeatedly. When personal survival conflicts with institutional stability, decisions skew towards self-preservation. That is why observers are watching not just court filings, but behavior, orders, statements, personnel changes, attempts to bend enforcement agencies. There is also the political reaction. Trump's base will interpret this as persecution. Fundraising will spike. Rallies will form. The narrative of martyrdom will intensify. That helps him in the short term, but it alienates the middle. Independents respond differently to power dynamics. They like winners. They recoil from collapse. A president who cannot secure his own finances looks incompetent. And incompetence erodes authority faster than scandal. Donors understand this. Big money does not back instability. It hedges against it. Already, attention is shifting. Potential successors are watching. The invisible primary begins when donors stop returning calls. When they start funding alternatives quietly, this seizure accelerates that process. Internationally, the damage is severe. Authoritarian leaders view internal legal conflict as weakness. They do not distinguish between lawful accountability and chaos. They see a state eating its leader. That emboldens them. It weakens deterrence. The projection of American stability is undermined when the president appears personally vulnerable. Markets respond to that perception. So do allies. Deals stall. Investments pause. Uncertainty spreads. A presidency consumed by legal survival cannot project confidence abroad, and confidence is currency. This is not about whether Trump deserves this outcome. Courts don't operate on desserts. They operate on findings. Judgments were entered. Appeals failed to secure protection. Enforcement followed. That is the process. The shock comes from seeing it applied to someone who long appeared untouchable. The veil is gone. The myth of invincibility has been punctured. Even if Trump ultimately delays or mitigates the damage, the image is shattered. He is being treated like any other debtor, and that image will not be erased. As the weekend unfolds, watch the technical moves, receiver appointments, bank levies, lien filings, emergency motions. Watch how federal agencies respond. Watch the tone shift. This is where narratives break. The deeper question is not about Trump. It's about the system. Can the law reach the highest office without breaking itself? Can enforcement proceed without triggering authoritarian backlash? Can democracy absorb this stress without fracturing? Those answers are being written now, quietly, in courtrooms, in filings, in enforcement actions, not in speeches. And the outcome will define the next era, because once the law touches the throne, it cannot pretend neutrality again. Either it holds or it collapses under pressure. This is not the end of Trump's story, but it is the end of his immunity. The machinery has engaged, and machines do not stop because someone is powerful. If this analysis helped you understand what's actually unfolding beneath the noise, you already know why staying informed matters. This isn't the last move. When the next one comes, you'll want context, not chaos. Subscribe so you're not caught off guard when it matters most.